Szanowni Panie Ministrze, jest mi niezmiernie miło powitać dziś Pana jako Ministra Sprawiedliwości Rzeczypospolitej Polskiej. To wielki zaszczyt, że Pan przyjął nasze zaproszenie do wygłoszenia jednego z przemówień Humboldta dla Europy. Szanowni Panie Ambasadorze, dear Professor Ruffert, dear Mrs. Ohlmeyer, dear Mr. Pidun, ladies and gentlemen. It is an honor and a pleasure to welcome you to this edition of Humboldt Lectures on Europe. We have the great honor to have the Polish Minister of Justice with us, who has just come back from the German-Polish government consultations. And I'm sure that you will be able to talk us some insights, give us some insight about this event, which, according to the first media coverage, marks a new beginning of Polish-German relations. And we all know how important it is, especially in these times, that Germany and Poland and Germany become or stay a driver of European integration, a constructive force for our common Europe. The Humboldt Lectures on Europe, organized by Professor Ruffert and his team, are among the university's most important public events. We invite very prominent speakers, political leaders, constitutional court judges, financial experts. And we are proud that some of these speeches are seen as intellectual landmarks in the debate on the future of Europe. And we take care that we cover a broad range of perspectives, as it is our mission as a university to provide an open space for controversial but constructive debate. We want to educate our students as critical European citizens who acquire deep knowledge and engage in active debate. With the Humboldt Lecture on Europe, we address a broader audience, as it is our mission not only to engage in excellent research and educate the next generation, but also to foster the exchange between the academic world and society. So this event is also part of our university strategy, the Open Humboldt Strategy. And with this strategy, we as Humboldt Universität fulfill our societal responsibility, not only to provide the society with important research results, but also to open a public space, an agora, where matters are discussed that are of crucial relevance for the society. Dear Mr. Bodnar, dear Minister, you have chosen rule of law as a key value of European integration as a title for your lecture, for your speech today. And I can hardly imagine a more timely subject. Undoubtedly, the European Union is entering a very critical phase. We are in between the two rounds of the French national election. The parties within the newly elected European Parliament are forming new alliances, and a EU Commission is formed that will face enormous challenges in the upcoming years. In such critical times, we need to reflect on the common values the European Union is built on. And with your expertise and experience, you are the best possible speaker on this issue. You have devoted your life and professional career to the fight for civic rights and the rule of law. As civil rights ombudsman, you were part of the fight for the rule of law under the former Polish government. You served as an expert on civil rights to the European Union and received important prizes for your lifelong engagement for the protection of civil rights. It is a great honor to have you here. Thank you.
Excellency Mr. Minister Bodnar, Excellency Mr. Ambassador Pavlos, dear Professor von Blumenthal, dear Professor Ruffert, dear students, ladies and gentlemen, distinguished guests. I don't speak Polish, but it is a great honor to welcome you today to the Humboldt speech on behalf of Stiftung Mercator. As Professor von Blumenthal already pointed out, this speech comes at a crucial time. Only a few weeks ago, European citizens have voted a new European Parliament. In some countries, the results have shaken up politics and considerably strengthened extremist and populist parties. Parties that have other priorities than strengthening the rule of law and democracy, fighting the triple planetary crisis, or promoting international solidarity and cooperation, On the contrary, they are often hostile to European values and try to undermine them. Under these circumstances, defending our common European values against their enemies from inside and outside Europe remains the urgent challenge of our time. When it comes to this challenge, Stiftung Mercator works together with many partners and civil society actors that are agents and accelerators for societal transformation. They are having in common a drive to uphold democracy, equality, rule of law, and human rights. As a private and independent foundation, we want to promote a dialogue between civil society actors working across different areas, across different countries, to identify shared challenges, develop practical solutions, and to create shared political visions. With the beginning of Russia's war of aggression against Ukraine, we have also intensified our work with regard to Europe's southeastern neighborhood, with some partners working intensively on the protection of rule of law, such as the Rule of Law Clinic in Budapest, where you held the keynote speech not long ago at the launch event. With this approach, we hope that, together with our partners, we can contribute to the stability and the sustainability of the EU and its neighborhood, be it in protecting the rule of law, addressing the climate crisis, driving forward a human-centered digital transformation, or in promoting participation and cohesion. We want to help strengthening Europe's role in an increasingly uncertain world through promoting foresight and providing science-based solutions. But there is still a long way to go. Dear Minister, only 2 weeks ago, during a last visit to a German university in Freiburg, you said, and I quote, "We are only at the start of this transformation," when addressing your ambition to transform, restore, and protect the rule of law in your country. We are thus very much looking forward to hearing how this transformation is unfolding, and most of all, which reflections you are drawing from your experience regarding the importance of rule of law for the European integration. This is even more meaningful for us as we have many young people, students here in the room, who will be dealing with similar challenges in the future and who can surely be inspired by your journey and your example. We at Stiftung Mercator are proud to be part of this event, which has established itself a great tradition to discuss the EU's most challenging issues with visionary European leaders. To conclude, let me say thank you to the Walter Hallstein Institute of the Humboldt University of Berlin for organizing today's speech. Thank you also to the Embassy of Poland in Berlin for their efforts in making today's event possible. And finally, my special thanks, of course, goes to you, today's speaker, Minister Bodnar. Thank you very much for being with us today, and I'm very much looking forward to your speech, and I wish everyone an inspiring and thought-provoking discussion. The floor is yours.
Dear Madam President, dear Professor Ruffert, dear Mr. Ambassador, dear representatives of the Mercator Foundations, distinguished guests, ladies and gentlemen. It is really a great honor for me to be here and to say a few words in my new capacity as the Minister of Justice of the Republic of Poland, but also taking into account my previous academic work in human rights organization, but simply as being a European. I think speaking here in the Humboldt University and in the context of in the work of the Walter Hallstein Institute is really something special for me, especially because in 2006 I have spent my whole summer here in Berlin when I was working on my on my PhD on multi-level citizenship, and at that time Professor Ingolf Pernice was the head of the Walter Hallstein Institute. And when I think about this, you know, this kind of a perspective reaching almost 20 years ago, and right now that today I had a completely different obligations in the morning, it's really like a remarkable thing for me. I would like to share some of my reflections concerning the rule of law, and I would like to present a little bit more general picture of what rule of law is and how and why rule of law is so much important for the European integration. Take into account what happened in Poland, what is happening right now in Poland, and also what are the challenges that Europe is facing. As you know well, Poland was experiencing between 2015-2023 something what we can name as an unconstitutional attack on the constitution. And in fact, the previous government was quite successful in creating this period of constitutional crisis or the rule of law crisis. And it is a little bit like a linguistic paradox that the formation that was responsible for this devastation of the rule of law is called Law and Justice. That is the name of the party that was doing this. But on October 15, 2023, with the highest turnout in the Polish history since 1989, Polish citizens voted that they want to have democracy and the rule of law back. And right now, we are in the process of repairing the situation. But I'm quite convinced that the Polish experience, this radical political crisis and breakdown of the constitutional order, but also current efforts to repair it can not only be interesting, but they could be quite important new chapter in the history of democratic transformation. I can imagine that there might be countries in future that come back from illiberal rule into the democracy, and maybe they will take advantage of some of the lessons that we take into account. I think that when we are talking about the rule of law crisis, we should start by saying that there is no universal definition of the rule of law. In fact, it was one of the major points presented by different people that were questioning the authority of the Court of Justice of the EU or European Court of Human Rights, that basically there is no definition, so it means there is no standard along which we can look into different laws that have been prepared. And in fact, if we look into different traditions, we can see that, in the United Kingdom, we may find books by Tom Bingham that are devoted to the definition of the rule of law. But here, in Germany, we may find extensive case law of the Bundesverfassungsgericht on the concept of the Rechtsstaat, but also commentaries by eminent legal experts. And if we would like to count pages devoted to the definition and to different sub-principles connected with the rule of law, I think it would go in thousands or maybe even millions of pages. And I think that irrespectively of what definition we adopt and how we think about rule of law, I think what is quite important is this general thinking that rule of law is about protection against arbitrary discretionary power. It is about right to have remedies. It is about predictability of the law. It is about playing fair play with respect to citizens. And I think that we should always underline the popular understanding of the rule of law. So what the rule of law means for the daily living of a citizen, entrepreneur, farmer, activist, teacher, or a doctor. We meet and talk during the European Championships in football. I think the football fans are looking forward to the Austria against Turkey match. But just let us think a little bit about the use of the VAR during championships. What happens when there is this problem, when we see the problem? The game is stopped, referee is informed by his assistants, he looks into some precise camera shots, he makes a decision, but then those decisions on penalty, lack of penalty, whether there is a goal or not, they are fully accepted. So there is no team that would endanger the security of the referee in such a situation, or that would resign from the game, or that would otherwise challenge the decision. Why? Because this VAR rule is accepted and legitimized by all participants of the sport, of the football competition. And I would like to say that in the context of the VAR, we know exactly what does it mean to comply with the rules. But I think this compliance with the rules is not so easy in the daily operation of the democratic state. And basically that is the reason of all different problems happening in all different democratic countries, but also those countries that are turning back from the democracy. And I think that we should also remember that the rule of law is part of this bigger triad, which consists of democracy, human rights, and the rule of law. It is also part of the major values of the European Union law. And let us just recall Article 2 of the Treaty on European Union. The Union is based on the values of respect for the dignity of the human person, freedom, democracy, equality, the rule of law, as well as respect for human rights, including the rights of persons belonging to minorities. These values are common to the member states in a society based on pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men. This principle seems to be quite simple, but we know that in practice it is not that simple, and we face a number of problems with the respect of the rule of law in different EU member states. But at the same time, it is quite difficult to imagine building the European project without compliance with this principle, because it is this connecting factor between EU member states and its citizens, and without it we cannot imagine equal treatment of entrepreneurs, operation of the common market, mutual recognition of judgments, but also responsible operation of the EU institutions. Poland, as I said, is right now in the process of the recovery from the rule of law crisis. I'm really grateful that you know my speech from Freiburg, so thanks to this I will not repeat some of the things that I have said at that time, because I think being here at the Humboldt University, you should speak not just about, I would say, like only basic typical things you have to do on a daily basis, but you should go a little bit beyond this. Please note that this rule of law crisis in Poland that happened between 2015 and 2023 was really massive, because it was about undermining the independence of the Constitutional Court, about extreme politicization, sometimes even partisanship of the prosecutor's office, civil service, public media, secret services. It was about violation of the principle of independence of judges. It was also change of the philosophy of the state's operation, in which the political will of the ruling formation was to dominate over the law, and it led to the erosion of trust in institutions and has built divisions in society. I would also like to add that rule of law was full of surprising actions by different state authorities, which were able sometimes even to act against their own institutions, especially courts and their officials. And different forms of harassment were diverse, petty, severe, but they have resulted not only in erosion but also of trust, but also in the fact that a huge group of professionals for long 8 years did not have any chance for professional development or promotion. And it applied to different groups, not only to judges and prosecutors, but also to diplomats or civil servants. Please note that this crisis was also severe because some of the judges have been suspended, some of the prosecutors were subject of different harassment actions. And I think that right now, for us, it is not just a question of recovery from the statutes, but it seems to me sometimes that some of the people that were suffering for all those 8 years, they suffer from a certain long-term trauma, and some of them might have even a difficulty to find their new way in a new democratic reality. But I think that this rule of law crisis created a lot of institutional problems and institutional challenges. And one of the most important problems that we have to deal with and we have to face is the vetting or verification of more than 2,000 judges that have been appointed as a result of the nomination by the politically subordinated body, which is the National Council of Judiciary. I will say some words about the process of transition, but I think that from the point of view of lecture, it is important to underline that this process was lasting for 8 years, but it was also characterized by a certain process of rule of law resistance or rule of law resilience. And I would like to underline that the most dramatic moment of resistance to the violation of the rule of law principle was the suicide protest by setting himself on fire in the center of Warsaw by Piotr Szczęsny. Piotr Szczęsny, who was a chemist, academic teacher, trainer, advisor, and consultant to different local communities and non-governmental organizations. In a letter that he has left, he presented himself as a so-called ordinary gray man. So this suicide took place in front of the Palace of Culture in Warsaw on October 17th, 2017. So just more or less 2 years after the process of change started. He left a letter in which he has written, "I protest against the authorities' restriction of civil liberties. I protest against the government's violations of the principles of democracy, in particular against the destruction of the Constitutional Tribunal and the destruction of the system of independent courts. I protest against the government's violation of the law, particularly the Constitution of the Republic of Poland. I protest against those who are responsible for this, including the President, taking any action to change the current Constitution. First, let them respect the one that is currently in force." In fact, if you read his letter, this letter is quite long, but if you read this letter, later on, you see to what extent he was predicting events to come. So 2017 was still the moment when quite many people did not predict what may happen later on with Polish courts, with Polish public media, with prosecution office. But he did it, and he sacrificed his life in autumn 2017. And that is why 6 years later, very symbolically, the newly elected Prime Minister Donald Tusk quoted a fragment of the Grey Man's manifesto in his expose in the parliament. But I would like to say that Piotr Szczęsny was not just one protester. He was one of many people that devoted their life, that devoted their energy in order to create different organizations of street opposition, of organizations of lawyers, organizations of people that were fighting or that were taking care about the rule of law. And there were also some politicians of the opposition parties that were quite vocal in this time. And I think that the elections that took place on 15th October 2023 was a little bit like a connection between, let's say, the political world and the world of number of different movements, protest groups, vulnerable minorities that were protesting against the process of changes. And it is not a mistake that one of the major slogans during demonstrations that were organized over this time was simply the word constitution. And that this word constitution and this wish to bring back the real meaning to the word of constitution was something that was connecting number of institutions. But interestingly, over this time, it was not just about protesting. I would like to say that especially organizations of lawyers decided to be quite active in advocacy, in lobbying, in pushing for different legal changes to happen. And here, the membership of the European Union proved to be extremely important in this regard. But interestingly, when we look back, we see that it was not just a question of, let's say, submitting cases to the Court of Justice of the EU, but also that it was a little bit like the process of mutual learning and mutual creation of different institutions to safeguard rule of law. And just let us look into those procedures that existed or that started to exist during those times. When all those protests started, we had Article 7 of the Treaty on the European Union, so-called nuclear option, suspension of voting rights in the Council for the member states. And this procedure has been started, but because of the bloc from Hungary, it has never been implemented fully. But still, because of the political character of this institution, it provided a forum for the discussion on what is happening in Poland, but also obviously in Hungary. But at a certain point, the European Commission realized that what may work here in the context of Poland is not Article 7, but it is Article 258 of the treaty, which is so-called anti-infringement procedure that could be brought by the Commission against violation of different standards by European Union member states. But interestingly, this procedure could be effected, could be used only after February 2018, when the Court of Justice has developed has developed the argumentation that this procedure is applicable to, that Article 19 of the treaty can be interpreted as guaranteeing the judicial independence of judiciaries in all different EU member states, that it is the competence of the Court of Justice to look into this. And as a follow-up to this, there were a number of cases brought by the European Commission. Then another, I think, interesting development was the series of preliminary references, preliminary questions made by Polish judges to the Court of Justice. So Polish judges started to actively use the procedure in order to address their concern regarding restriction of judicial independence. And please note, all those procedures resulted in a situation that, thanks to the European Union and thanks to the Court of Justice, some of the changes have been frozen, or some of the changes had to be even revoked by authorities. So any step like this was a little bit like the fresh air for the Polish civil society to continue and to be still in the protest. But there were also some other mechanisms. So, for example, the Commission started to develop the rule of law reports. So right now they are produced, they are prepared regularly, and you can compare the situation in different EU member states. And finally, European Union, European Commission and the Council has developed so-called conditionality regulation. Conditionality regulation, which says basically, if you do not follow rules, it means you will not get the EU money. So more or less money for obeying values. And this conditionality scheme has been used in order to suspend funds from the EU Recovery Fund. Please note that what I like to say is that we have observed, and maybe it is still subject of different analysis, the process of on the one hand, illiberal practices in Poland, Hungary, but at the same time, the process of developing some new standards and some new mechanisms in the European Union. And it seems to me that those mechanisms could be used quite effectively in the context of accession countries or in the context of some other EU member states that may backslide from democracy standards. So Poland was a little bit like a laboratory for changes, but interestingly, we are once again laboratory of changes in the context of transition back to democracy. Please note that just recently, Commission has decided to close Article 7 procedure. So there was no case in history before that the procedure has been started and has been closed with respect to any country. The same is with the implementation of milestones concerning the EU recovery money. But I think what is extremely important, and I think it is the result of the mission, or maybe it is lifetime achievement of Judge Kun Lennart's, President of the Court of Justice of the EU, that this whole series of case law of the Court of Justice resulted in one breakthrough case, which is the judgment of 16 February 2022. And in my opinion, this is a judgment that could be regarded as a kind of a monument for European integration. The Court of Justice said, it's a longer quote, but I would like to put it clearly. I start. It must be borne in mind that Article 2 of the treaty is not merely a statement of policy, guidelines, or intentions, but contains values which are an integral part of the very identity of the European Union as a common legal order, values which are given concrete expression in principles containing legally binding obligations for the member states. Even though EU respects the national identities of the member states inherent in their fundamental structures, political and constitutional, such that those states enjoy a certain degree of discretion in implementing the principles of the rule of law, it in no way follows that obligation as to the result to be achieved may vary from one member state to another, whilst they have separate national identities inherent in their fundamental structures, political and constitutional, which the European Union respects. The member states adhere to a concept of the rule of law which they share as a value common to their own constitutional traditions and which they have undertaken to respect at all times. So we may differ regarding details, we may differ regarding our traditions, we may differ regarding our structures, our political solutions, but at the end of the day, we have to respect the same value, which is the rule of law, because we are bound by the European Union. And I think it is important to remember, because in my opinion, this judgment of 16 February 2022 is something that would set the line for the further development of the European Union and for the case law of the Court of Justice. And I think by this line of jurisprudence, we can also observe how the Court of Justice has built itself as much more powerful institution in the context of the rule of law compliance control. But please note that this whole case law of the Court of Justice has happened before the process of changes started. So starting from 13th December 2023, Poland is in the process of the rule of law recovery. This process is quite complicated and includes different dimensions, and it has a lot of constraints. One of the constraints is institutional setting. So simply there are institutions that are still protecting their statutes. They do not agree with that there is any need or any necessity to make any change. So such institutions as the National National Council of Judiciary or the Constitutional Court, they still believe that what happened between 2015 and 2023 is perfectly okay and is not any threat to democratic values. Second, the ruling coalition these days is not having the constitutional majority, or is not even having a majority to overturn the veto of the president. And Mr. President is, I would say, quite happy with things that he has subscribed to, undersigned to throughout all those years. And I think that it is also difficult because the depth of personal changes in different institutions, including courts, is such that it is quite difficult sometimes to achieve real changes, because those people are not only protecting their perception of the institutional setting, but also their own individual and moral choices that they have made. So basically that is the background we are facing, but moreover, in order to make a proper transition, you must take into account not only institutional dimension, but also personal dimension, which means that what is the process of changes in different institutions, and also accountability processes, so whether people face justice for abuses they have committed over last years. But still, irrespectively of those problems, we, in order to make this transition properly, we do our best to follow certain principles. So for sure we know that we should comply with the EU law and European Court of Human Rights standards as guidelines in our changes, that we should be open and transparent in our actions, we should have a proper cooperation with the civil society and proper comprehensive legislative process, that any institutional changes should be made within the limits of law, that we shouldn't go beyond the existing law, even if this law could be quite controversial, that if, in the context of accountability, if justice is going to be served, it should be made in order to achieve justice and not in order to achieve revenge, which means that you must comply with procedural rules and fair trial guarantees. And finally, I would like to say that we must be patient, because if the process of erosion lasted for 8 years, the process of repairing may also take some period of time. Maybe not 8 years, I hope so, but at least not, but for sure not just half a year or not even one year. I think that it will take us a couple of years to get fully out of the problem that has been created. And moreover, I would like to underline that this process is quite unique. I think there is no comparison in any other country, because first of all, we cannot compare it to 1989, because there is no similar moral stigma to those that were ruling Poland before 2023 as you compare to the 1989. And second, we have the situation that membership in the EU was at the same time kind of a safeguard in order to protect democracy, but at the same time, it is a little bit like the stabilization line in the process of further changes. And I think this specific position of the EU was, in the context of the transformation, was made in a book, which was a little bit kind of a prophet type of a book, edited by Professor Armin von Bogdandy from Max Planck Institute, that was called Transition 2.0. So that was the book that has been published in the end of 2000. It it was not even the end, it was autumn of 2023 when certain changes in Poland and hopefully in Hungary have been predicted. And basically the major argument of this book is that because of the special position of the European Union, this process of coming back to democracy is of special character. Ladies and gentlemen, as I said, this process of the rule of law recovery is a quite complicated one and requires a lot of passion, energy, and determination. But I think we are already at this stage that we can share with you, and I would like to share with you, some of the lessons that we have learned over the last couple of years, and also because of this moment of transition back to democracy that could have some, let's say, universal value, and they are not just limited to taking into account the Polish perspective. And let me sketch 10 lessons for Europe from the Polish rule of law crisis. So I think the first lesson is that the principle of rule of law and judicial independence is of universal importance. I think it sounds quite straightforward, and it is, I think, not a big discovery. But I would like you to just think about one event that took place in Warsaw 3 years ago. It was March of 1,000 Guns. So please imagine that there were a couple of thousands of judges that came from different EU member states. And basically, they were wearing different gowns with different colors, with different symbols. But at the same time, all of them were just judges. So simply for them, it was quite obvious that if you are a judge, it means that you are independent from other branches of power. So basically, that this value of judicial independence, irrespectively of those, let's say, political and constitutional and societal setting in different EU member states, or also other countries like Norway, is basically very common, that you must be simply independent and you have to take care about this universal value, which is the judicial independence. The second lesson is that rule of law, in my opinion, cannot be taken as given once and for all. I think that, to be honest, if I remember back 2015, we thought that basically, the process of transformation has finished. We are done. We have the Constitution, we have the Constitutional Court, we have all those, great case law of the Polish Constitutional Court, we have handbooks and definitions of the rule of law. We have even, can you imagine, there was a proper annual cooperation between the Polish Constitutional Court and the Bundesverfassungsgericht, so judges meet with each other, and they were talking about some cases. So that was what we thought about in 2015. And then 2 years later, we learned that, sorry, it is not like this. It could be taken over. And I think that this lesson gives us the opportunity to think, what is the role of participants in the system to say that you should take care about the rule of law? So in my opinion, one of the major lessons from Poland is that judges, prosecutors, attorneys should talk, should promote, should take on themselves responsibility of not just participating in the system, but promoting to others why this system is important. So there is a very interesting case by Strasbourg Court, Waldemar Żurek against Poland case, in which the court says that it is not just it is not just a freedom for judges to speak, but it is almost like a duty of them to speak when it comes to the defending rule of law. The third lesson is that the key measure to uphold the rule of law is constitutional education, is talking about constitution at all different events, places, and so on. And just imagine that, we are meeting here, we are waiting, as I said, for the Austria-Turkey match, but there is one guy, Robert Hojda, who is a 50-plus gentleman wearing kind of a Harley-Davidson outfit, and he is just right now organizing a meeting of so-called Tour de Konstytucja, Tour de Constitution, in Brzeg, a tiny city in Lower Silesia. And during this meeting, he would most probably meet, 40, 50, maybe 60 citizens of Brzeg that are interested in talking what is really this constitution about, why those constitutional values are important. And it is not just one event. I have just selected this one because it happens right now. He's making that kind of events, 100, during the whole summer, and he's always inviting different experts to be with him, judges that were subject of those disciplinary cases, experts that are just promoting in non-political way what is the value of the Constitution. Or just think about a group of 4 lawyers that decided in 2015 to establish a new initiative, which was called Free Courts Initiative. And their idea was just to record short social media movies about why judicial independence is important to your neighbor, to entrepreneur, to some business person. So just in clear, precise terms, explaining to general public why rule of law matters. So these are just 2 examples that had, in my opinion, like a transformational force in the context of understanding of some of the values in the Polish society. The 4th lesson is, and it is a little bit plagiarism on my side, but I think that it fits nicely here, which is the lesson brought to us by Timothy Snyder: you should defend institutions. I think that I don't need to introduce to this audience who is Timothy Snyder, but in his book on tyranny, 20 Lessons from the 20th Century, he included one lesson which is called lesson number 2, defend institutions. So he wrote that institutions help us maintain decency, however, they also need our help. Don't talk about our institutions if you do not move from words to deeds and act on their behalf, because institutions will not defend themselves. And to be honest, I was feeling this when being the ombudsman, when people have decided to select my institution and to defend my institution by making demonstrations, petitions, different kind of actions. And I remember well that this approach of defending institutions, whether these were ombudsman, media, or courts, was quite important from the point of view of creating a public change. But when we are talking about institutions, we come to the lesson number 5, which is that institutions must explain to citizens the very sense and idea of their existence. What I mean by this? I mean that sometimes we have this feeling that everybody knows what we are doing in this or the other court. Everybody knows what we are doing as prosecutors, or some regulatory agencies, competition protection bodies, ombudsman institutions, and somehow we take it for granted. And at the same time, institutions do not take enough care that they should explain to citizens what is their role. Not only in terms of results that are brought to citizens, but just explaining all different, sometimes difficulties that are connected with this. And in my opinion, it is extremely important in the age of social media and fragmented public discourse that we are taking knowledge about different things in our society from different sources. And even today, I talked to Minister Dr. Marco Buschmann. We talked about this, and he told me that, you are right. There is no any longer a daily tradition of watching Tagesschau by the whole family in our families. He said, always, we are sitting as a whole family, and then during breakfast we are discussing what was the news. Right now, not any longer. Nobody is kind of creating this communicative context that would be required to understand things in the same way. And I think this perspective applies equally to whether that institutions must take more burden on themselves in terms of explaining what they do. The 6th point is that, 6th lesson is that rule of law is not about institutions, but it is also about the attitude of certain people who believe in the meaning of their service, and especially in their professional oath. That professional oath that they have made, that they are bound by the Constitution, is not just a formality, but it is a lifelong commitment. And if I look back, I see that there were not only just like a group of citizens, group of civil society leaders, but there were also some professionals that took really extremely seriously what they have promised to. So I remember, for example, Judge Igor Tuleya, who was suspended for 2 years because of his activity, but because he was a judge and he promised to serve to the Constitution, he never allowed himself to interfere into his choice. He resisted, and and he waited for justice to come, but he was a symbol for all of us, as well as a couple of other judges. And I think this understanding of this connection between the institutional setting and the individual position, individual perspective of how to take advantage of how to keep the promise of this professional oath is something extremely important in our democracies. The seventh lesson is the existence of international human rights norms and their embeddedness in the domestic legal system. You know, we are quite happy that over those years, a number of people, number of lawyers, civil society activists could professionally use litigation of cases before the European Court of Human Rights or submission of different positions to OSCE or to United Nations. And European Court of Human Rights is especially important here. But I think it would not happen if we would not take care before 2015 into creating kind of a cult type of approach towards the European Court of Human Rights and the respect towards judgments of the European Court of Human Rights. So because values of certain international human rights treaties were embedded in, let's say, among legal professionals, among civil society, it was much easier to use it in order to protect ourselves against the tide. So I think that we should not also, once again, treat all those human rights instruments as just a formality, but we should really invest into the public and lawyers' understanding that those institutions are and that they have at a crucial moment they have an important meaning for our societies. The eighth lesson is that the European Union law itself could have had a role in slowing down the undemocratic changes in Poland, but it was unable to stop these changes. Please note, what happened with the European Union was kind of giving us a little bit like the lesson, okay, guys, you know, listen up, we see a problem, maybe you should not go forward with this, you know, here and there we'll indicate you breaking rules. But all those indications given by the Court of Justice, by the Commission, by the rule of law reports, by Article 7 procedure, was kind of giving a chance for the Polish civil society, for Polish opposition, for Polish lawyers to stand up and to say, okay, we cannot agree with this. But please note, European Union does not have a chance to stop the process. It must have so we must understand this process as a kind of a freezing mechanism and not a mechanism that would stop the process if the political discussion is in a completely different moment. Please look how the situation looks for last years in Hungary. It is much more difficult for the European Union to move forward because the civil society is much weaker as compared to Poland. The ninth lesson is that standards created in the context of Polish affairs could serve to reflect on the situation in individual member states and candidate countries. And I think that this lesson shows that we should monitor democracy on an ongoing basis, especially since its enemies do not sit on their hands, and especially because they know how to destroy democratic discourse. Just look at the book by Wojciech Sadurski about the changes in Poland, Poland's constitutional breakdown, and at the end of this book there is so-called playbook for authoritarian leaders. So if you just repeat this playbook, you know how different processes may go forward. But Sadurski did not write it in order to instruct authoritarian leaders, but he has written it just as a warning. So because we know it on the basis of Polish experience, we should be prepared about process of changes to come in some countries that are suffering from some illiberal disease. And the final lesson, the 10th lesson, is the lesson by my mentor, Professor Mirosław Wyrzykowski. And this lesson is, I quote, "You can have 6 locks on doors instead of 1, but it will not prevent you from a 5th." So what does it mean? It means that, you know, sometimes we have this question, okay, can we protect our democracy even more by creating some constitutional or legislative rules that would prevent any other further, any future democratic backsliding? And then Professor Wyrzykowski says, yeah, but you know, if you have a thief, it's not a problem for him to break one lock. He may break 6 locks on the door. He may still get into, because it is the question of passion, creativity. It is a question of breaking simply rules. So even if you think about the most far-reaching rules, it does not mean that they will protect the democracy by themselves. You must think about all those other night lessons that I was talking about. And I think the most important, what you have to take care about, is that every citizen should be a watchdog barking on this thief and thus warning him of some negative consequences. Ladies and gentlemen, these are those 10 lessons, and let me just go to conclusion. I think it is, for me, it's obvious that rule of law is a key value for the European Union. It is not, please note that European Union is not only about controlling EU member states, but it also has to protect rules of the game and has to comply with the rule of law standards, especially because the European Union is exercising public power, and this exercise of the public power is important, taking into account new areas of life that are regulated at the EU level, and that we should be interested in that the EU power is crucial in the context of controlling some internet giants, technological companies, climate change issues, and all different developments that emerge on a daily basis. But I think also that the European Union needs a kind of a binder to build a European identity. And there is no better idea than rule of law to guarantee security, especially against arbitrary decisions or some authoritarian tendencies. And just look at the fight of Ukrainians. They fight for the EU membership, not only to be just EU members, but they would like just to share the same values. Similarly, civil society in Georgia and the fight against the foreign agents law on restriction of international funding to NGOs. They are also fighting because they would like to be part of the same family of values. So in my opinion, if a new Iron Curtain is going to be created, it will be built between the zone of the rule of law and the zone of lawlessness. The European Union cannot limit itself to the institutional sphere. It must take care of public awareness and understanding of the functioning of institutions. It must support member states in this respect. And the EU needs the rule of law in order to ensure security and stability. And the example of Ukraine and some other potential candidate countries shows that the rule of law is a foundation and model on which the future of Europe is based. And please note that the same thinking goes from the Reykjavik Declaration that has been adopted in May 2023 during the Council of Europe summit. In my opinion, taking into account different experiences, Poland and Germany have a key role in reactivating the activity of the Weimar Triangle in the context of strengthening the idea and practice of the rule of law. And in this context, I think it is important to remember, to recall the recent article by Timothy Garton-Ash that has been written for the New York Review of Books. And in this article, Timothy Garton-Ash claims that Germany needs sogenannte Gesamt-Europa-Politik, an all-Europe policy putting together what have been in the past been the largely separate Europa-Politik, meaning EU policy and Ostpolitik. He claims that strategic commitment of Germany is required in order to defend European values and our way of life, as opposed to some existing or emerging superpowers in the world that tend to believe in a completely different set of values. And as Timothy Garton-Ash puts it, Germany cannot do any of these things on its own, but without Germany, none of them will happen. And Poland is ready to cooperate with Germany, hopefully with France, on anchoring the rule of law as a key value of European integration. And for me, it was a great satisfaction that today in the morning I could talk the same terms with Minister of Justice Marco Buschmann on those issues. Finally, I would like to refer to the legacy of solidarity. the great social change movement that led to a bloodless change of the system in 1989 in Poland. And I would like to recall words of Jacek Kuroń, one of the pillars of the democratic opposition in Poland, basically starting from 60s to almost 90s. That was a key architect of the political transformational change, a man who served many years in prisons of the Polish Republic. But when he was talking about different social movements and dozens of civic initiatives, he was appealing, don't burn the committees, build your own. He meant by this, don't burn Communist Party committees, build your own committees. And in the same vein, I would like to say that in order to defend rule of law, we have to build committees on a daily basis. We have to take care about civic attitudes. We must be aware of challenges faced by populist claims. We have to explain the role of institutions. We must build European project on European citizens who fully understand and share that rule of law is their core value, the guarantee of their decent life in a modern European and democratic society. Thank you for your attention.
I think we could make it anyway, but it's perhaps better that you can hear us via the microphone. So thank you so much, Minister Bodnar, for this very inspiring speech, and I'm still impressed that you were at our institute some years ago to prepare what you have now to accomplish in your country. So, as always, students, in particular our students of Humboldt University, but everybody else is invited. If they have a question to our speaker, please raise your hands. I'm sitting very down here, but there's a hand in the last line. I hope if you stand up and you can ask a question.
First of all, Mr. Bodnar, dziękuję bardzo for your speech. It was very interesting. My question concerns the process of transformation. And there's a German saying that means the purpose doesn't legitimize the means. And as I understand it, the Polish government right now is ignoring all the judgments made by the Polish Constitutional Court, which is, quite frankly, quite the same the peace government did until it established their own judges in the court and the court ruled to their liking. And my question is, don't you see the danger by doing so that it becomes kind of a habit for the next Polish government to do the same? And I know your reasons are fair and just, restoring the rule of law, but can the rule of law be restored by ignoring it? Thank you for your answer.
It is a difficult question, obviously. You're right that we have a serious problem with the Polish Constitutional Code. The Polish Constitutional Code is suffering a lot from a crisis of its legitimacy. According to public polls, the level of public support and public trust to the Constitutional Code is more or less 20 to 25%, which is, I think, the lowest in the public institutions. Second, we have experienced over last years a number of situations when the Constitutional Code has been used in order to promote, I would say, a very strong political role. So just to mention, restriction on the abortion rights, or two judgments that were very much similar to the Russian Constitutional Code, undermining the binding nature of the European Convention on Human Rights, or two judgments that were undermining the EU membership. Even myself, I was once a victim of the Constitutional Code. I was kicked out from the position of the Ombudsman. Basically, the Constitutional Code said that I cannot serve in so-called interim period. So I finished my term, and there was a moment of waiting for the new Ombudsman, and basically the court said that, sorry, but you cannot wait for the new Ombudsman to come. Because allegedly provision on the basis of which I was working and operating was contrary to the Constitution. But basically, after elections, we've realized that you cannot achieve any change in Poland with the constitutional court that would operate, because its mission, its full mission, I would say these days, is to block any changes that happen in the Polish reality. So the Constitutional Court is using a lot of different prior restraint orders in order to stop even some of the personal changes in the government. But in order to legitimize the process, there was a resolution adopted by the Polish Parliament in which two problems have been indicated. One, that the Constitutional Court is composed of 3 persons that do not have a position of a judge, because of by virtue of the jurisprudence of the European Court of Human Rights, and that the current president of the Constitutional Court, in fact, she finished her term in 2022, in December 22, and she's in fact illegally serving as the president of the Constitutional Court. And on the basis of this, there was a call that public authorities should basically take into account the resolution of the parliament. And for example, I do not participate in proceedings before, being the prosecutor general, I do not participate in proceedings before the Constitutional Court. But what is our intention is to sit to the table and to establish the new Constitutional Court. But we know well that in order to do it, we must have a 2/3 majority in both chambers of parliament. And I hope that we'll be able to do this, I hope in the second half of the year. There are relevant laws that are prepared. Even today, the Legislative Committee in the Senate was discussing changes to the Constitution on this. So we do believe that we'll stop this process and that we'll revive the independent Constitutional Court.
Thank you so much for your answer. Now I have somebody here, the gentleman.
Hi, dzień dobry. I want to ask you, because you've talked a lot about humanitarian law and human rights and international law, and I want to ask you if you don't think it's a little bit hypocritical from the Polish government to talk about these values, which are important, and I see a lot of improvement in comparison to the PiS government, but the way the Polish government handles the Polish-Belarus border, I think goes against a lot of international and humanitarian law. I mean, mostly the illegal pushbacks and the thing that the Polish government doesn't allow the asylum seekers to actually claim asylums, and instead pushes them back to the Belarusian territory. And I wanted to ask you if you think that's okay to do these things, and do you think that goes with the importance of the rule of law? Thank you.
You see, if you teach law here, the students don't let you escape with any.
I'm prepared. I think that we must understand one thing, that we have a completely different situation these days than we had in 2021 when the Belarusian crisis emerged. Right now, and we do not have any doubts concerning this, the crisis at the border is not just a situation of some voluntary getting to the border by people from different sub-Saharan or Arabic countries, but it is to a great extent orchestrated and prepared by the Belarusian and Russian secret services. It is basically part of the hybrid war that is undertaken against not only Poland but whole European Union. Just look, at the Polish-German border. Polish-German border, although it is part of the Schengen zone, it is subject of a very strict control these days because of the situation at the Polish border. It is not just I think the queue today was at least for a couple of miles. So basically, I think that we should understand this. The second point is that we have a situation that sometimes daily there are more or less 100, 200, 300 crossings of border. So if you have a group of 100, 200 people that are at one point trying to cross the border, it is quite difficult to even register them because you would need to have at the border at the given moment at least 500 people that would register them and make proper procedures with them, and the whole situation is for the destabilization of the border situation. Moreover, I've said that it is a part of the hybrid war because we had, and we didn't have it in 2021. Sorry to say it, but it's good that we didn't have it. But right now, we have a lot of kind of terrorist or semi-terrorist attempts made by upon inspiration by secret services from Russia and Belarus. So there were more than 10 fires that were attempted or that were put in different places in Poland. So this is a part of the bigger picture. And my feeling is, and I'm really convinced that this government is trying to find a proper balance between the respect for international human rights norms and the Polish constitution, and the need to provide for the security of the border. And we simply try to do our best in order to have this balance. Also, there is a quite intensive dialogue with the civil society, which was not the case some time ago. And also, there is this kind of a policy that whoever is crossing, we cannot allow that anybody is, somewhere lost in the forest without any humanitarian aid. So there are a lot of activities made by border guard, by local authorities in order to support people that are crossing the border. Thank you.
Thank you very much. Any further questions? There is one question over here, please. Yes.
Panie ministrze, dziękuję serdecznie dla przemowy. The German government has imposed repeatedly border controls on its border towards EU member states. Of course, this raises some legal issues, including but not limited to fundamental rights and the citizenship of the Union. How would you describe your legal view on this?
I'm very much in favor of the Schengen zone and lack of any restrictions, and I see that it creates a problem from the point of view of free movement of goods, persons, and so on. And basically, we should fight for not having any controls like this. But in order to do it, we must have borders that are secure, simply. So I'm basically coming back to my previous statement. And in my opinion, it is extremely important to take joint responsibility for borders. I think that Poland is right now more or less in the same position as some Mediterranean countries were. I don't claim like in terms of the same situation, but simply in terms of numbers. That the situation is almost comparable to the situation from the Mediterranean Sea. But at the same time, please note that we are facing a situation when next to Polish border there is ongoing war. There is ongoing war. There is a constant security threat for Poland. We are a neighbor country to Russia. I mean, this Kaliningrad region, and I think that we should take into account that the whole stability of Europe is such an important value, and I think that was one of the reasons of today's German-Polish consultations, to show that basically we are together in this European endeavor, and that's why my feeling is that we are afraid of what may happen with France as a result of elections, because if there is a problem with some future cooperation with France, then basically there is more irresponsibility on both Poland and Germany in the context of protecting European Union as such.
Thank you so much. Any further questions here? Yes, please.
Thank you, Minister, for your speech. I wanted to ask you about the judgment of the Supreme Court of the United States and about the immunity of presidents in regard to official acts, and whether you think it might be a dangerous precedent for new governments forming in the EU, because the US has long been a partner and a role model concerning democracy and rule of law for European states? Thank you.
I think judgment of the Supreme Court of the US is just one of the problems. I think that we are all observing the consequences of the presidential debate, and we wonder what may happen in autumn in the context of presidential elections. But please note that on the same date, the US Supreme Court has issued another judgment about the relationship between so-called regulatory agencies and entrepreneurs, and also it decreased powers of the regulatory agencies and increased powers of traditional businesses in the US, which also could be quite important from the point of view of funding of Donald Trump, but also from the point of view of supporting this traditional political base for Donald Trump. You know, when I hear about immunities, you know, I don't have that much time to, let's say, deal these days with developments internationally, because right now I'm dealing with some procedures for lifting immunities to some members of the Polish parliament. There is one case which is part of this accountability process that I have mentioned, which concerns some of the people that were serving as deputy ministers of justice in my ministry, and basically one of them has been lifted parliamentary immunity last week, and another one is going to have a hearing in the parliament tomorrow on his immunity. And you cannot imagine how much those people don't like the situation that I'm quite invasive in terms of pushing forward with those procedures.
Thank you so much. Herr Grimm, bitte.
I'm aware that the present majority in Poland doesn't have the majority that is necessary to amend the constitution. But let's assume for a moment you had this majority. Would you think that there are lessons to be drawn from the experience of the last 8 years with regard to the Polish constitution? So if you had the majority, would you recommend amendments? I ask this question also because we in Germany are in a period where we consider amendments to our constitution to better protect the Bundesverfassungsgericht against a capture by a majority that would be interested in transforming Germany into a more authoritarian system.
Thank you very much. You know, for sure, you know, for us, changing the constitution would mean that we should reestablish the value of the Constitutional Court. I said already about it. I think we should strengthen protection of some rights in the Polish constitution, because Polish constitution adopted in 1997 is pretty decent, but still the world is changing, and you know, we have this evolution of human rights, so we could strengthen it. There are some institutions that are either not properly working or are simply missing in the Polish constitution. So, for example, we have the body which is called Tribunal of State, which is the major body for constitutional responsibility of top officials, and basically because of the a little bit inadequate language of the constitution, inadequate formation of this institution, in fact, it is not working, and it didn't have any serious cases over the last 20 years. But, for example, what is quite striking, we do not have a prosecution service in the Polish constitution. So, you know, we have a whole sub-chapter on the National Broadcasting Council, and there is nothing on the prosecution service. So I think, and Polish prosecutors, they really need some level of independence, and they think that it should be part of their identity. You know, I know about your constitutional discussion, and you know, I would like to tell you one thing which I don't understand in your constitutional system, and I will be very frank with you. You are very frank with me, so I will be frank with you. I don't get it. Why do you allow for judges to be members of political parties? Okay, I know, I even discussed this with Minister of Justice, and he said to me, it is this tradition. We always accept, people who have some kind of experience in the state administration, and the fact that somebody is a member of the political party does not mean that it translates into his adjudication. But in my opinion, and maybe I don't understand your culture in this regard. But for us in 1989, it was obvious that no judge should be a member of any political party. No prosecutor should be a member of any political party. And after 2015, I think about it even more, because I think it is a question of perception, okay? So if there is somebody who is in a court or in the constitutional court who had like this very strong affiliation with a political party, then it is one of the best ways to undermine the credibility of the court, especially from those guys who are not respecting rules of the game, who are not, let's say, in the same tradition of in the same legal culture. So so think about maybe some restrictions of membership in political parties, different organizations, and how it may contribute to the process of perception of some judicial bodies as being fully independent.
Okay, thank you. So I think we should collect a last series of questions, because I now see 3 hands. Is this okay for you? If we have 3 very short questions in the end, so please go ahead.
Dziękuję bardzo, Tesh, dear Minister, for being here. I heard reports about an incident at the Belarusian border at the beginning of last month, in which Polish border guard soldiers fired warning shots in the direction of a group of migrants which forcefully tried to cross the border. Afterwards, one of the soldiers was charged by prosecutors, and as reports stated, the investigation into these charges were closed after political interference. How do you justify this when at the moment it's the stated goal of the Polish government to re-establish the rule of law? Thank you very much.
Of course, I know this case being heavily commented in Poland. This case for me is quite interesting from one angle. Can you imagine that being the Prosecutor General, I was not informed by my deputy that this case has appeared, only because this deputy has been appointed just before the moment of the change of the government, and the law on the prosecution service is such that his position is totally cemented. Okay, so that I cannot remove him without the consent of Mr. President. In fact, there is a disciplinary case ongoing against him because first, he didn't inform me. Second, when he was spotted that he knew about this case and he didn't inform anybody about this case, then he started to basically say untrue things publicly, and at the end of the day, he even started to accuse me about some of the issues connected with the case. That was really like a very strange, like a situation, but it a little bit shows the level of emotions that we are having and problems that we are having, especially in the prosecution service. But here in this case, the case has not been dropped. The only thing that has been dropped here is the use of those kind of a preventive mechanism with respect to soldiers, because they have been suspended and they have been so they couldn't serve. So only this has been lifted, but basically the case is ongoing. So there was no decision. So there is no decision like this. And I think that this case should continue, and simply courts should prosecutor's office first, and then courts should evaluate what happened in this case. Please note that this case was also quite interesting from a, let's say, political angle, because the case happened in March, and interestingly, it has been disclosed to the public opinion just 2 days before elections. So I don't know why. So there is like one big mystery to me that maybe this case was instrumentalized for the purposes of elections.
Thank you. Then two questions we had there. Yes, please.
Dziękuję, panie ministrze. I just wanted to ask you about LGBT and women's rights in Poland. Our past government introduced some very strict abortion laws. Indeed, like probably as strict as Malta, or I mean, most strict in Europe, probably. And it was also a big reason for demonstrations against the government. And what is the current government doing to address those issues that are so important to many people in Poland? And also what this government is doing to address LGBT rights issue, like LGBT discrimination during peace government in DVP, but also by the president during political campaigns, was abhorring, probably not only to people outside of Poland, but to much of Polish population. And what are you planning to do? Thank you.
Thank you. Maybe I will start with the second point. First of all, with LGBT plus rights, I think what is important is the change of atmosphere, like total change of the atmosphere. Just, I remember one day, which was one of the most important days in my service as the minister, that I invited representatives of NGOs, of LGBT plus NGOs to my office. And basically I started with my apology for everything bad that happened to them over last years, because basically from the same ministry, they heard all the time like a negative homophobic content against them. So I thought that it is quite symbolic that being representative of this ministry, I should behave in a completely different way. But of course, words is one thing. Second thing are different legislative changes. So there is a draft law about extension of the hate speech protection to cover such grounds as sexual orientation and gender identity, and this draft law is going to be soon adopted by the government as the governmental law. Right now there is a big discussion regarding the scope of the registered partnership law in Poland. So basically there are discussions within the ruling coalition how broad or what kind of rights should be included into this registered partnership law. So basically there is one party, which is Polish Peasants Party, which is a little bit kind of a conservative Christian oriented party that is not saying that they are against, but they have some problems with some of the rights that should be associated with the registered partnership law. But my feeling is that it's a question of just weeks to finally agree on what is going to be there and to adopt it. And then we have to come back to the adoption of the Gender Recognition Act. Please note this act has been adopted in 2015 in Poland, but then it has been vetoed as the first veto by Mr. Andrzej Duda. So right now we are going to come back to this. Interestingly, in Poland you can make a gender recognition just on the basis of the case law of Polish court. So it is just one of these very, very special moments in the Polish law where we have like a typical common law system. So no provision at all, but it is still possible to change, to make a gender correction in Poland. But basically we have to regulate it properly with legislation. Being the Prosecutor General, I also, what I'm doing these days is also kind of cleaning my docket from some strange interventions that have been made by my predecessors concerning LGBT plus rights. So they were kind of looking for different problems and how to interfere into the life of LGBT plus community. And right now I'm kind of recalling some of the general instructions. When it comes to the women's rights and access to abortion, there is one interesting development concerning women's rights. Just last week, Polish Parliament adopted a new definition of rape, so that the rape is if there is no consent of a second person. So basically it goes into the direction of the compliance with the Istanbul Convention. When it comes to the abortion, it is much more complicated because of the political discourse also within the coalition partners. But it seems that first it will be the law that would be adopted that is decriminalizing the help in abortion. And it would have an important aspect, important meaning for number of organizations that are helping with abortion, also with so-called abortion tourism. But I think what the Minister of Health is doing is, I think, quite interesting. That please note that this judgment of the Constitutional Court that I mentioned has restricted access to abortion due to the genetic disease of the fetus. But the Polish Ombudsman for Patients' Rights made an interpretation that if a woman is in a situation that she cannot make an abortion due to the genetic disease of the fetus, it may create a danger from the point of view of her mental health. And basically it means that you can go forward with the second condition for termination of the pregnancy, that when the pregnancy is a threat to the woman's health or life. So it creates an opportunity to extend the use, to have a broader access to abortion. And also, you know, my role as the Prosecutor General is such that I'm right now finishing my work on so-called general indications, general guidelines of the Prosecutor General, how to basically deal with that kind of cases, because my feeling is that there was like kind of too much pressure of the prosecution service and too much kind of a fear among medical doctors in performing abortion in those situations when it should be simply done. So we are trying to do our best, taking into account also some of the problems within the coalition, into the democratic coalition, but still to move forward with things as much as possible.
Thank you so much. Last concise question, please.
Mr. Bodnar, thank you for taking your time this evening, and I wanted to ask you, you already mentioned that the European Union and European law was able to help Polish citizens and the Polish civil society to resist the authoritarian shift, but it's also come under fire, not only, but especially by the court, by the Constitutional Court with some judgments, also referring to judgments from the German Constitutional Court with rather reserved perspective on European law. How do you think can the European Union, its institutions and European law be protected in Poland, but also in other European countries?
I think that Weiss judgment by German Constitutional Court didn't help us. It was used extensively by Polish, by the previous government as an argument in order to undermine the credibility of the Court of Justice of the EU. And in fact, to a great extent, the judgment of the Polish Constitutional Court of 2021 that was undermining the Polish membership in the EU was to a great extent based on a similar line of argumentation as the Weiss judgment. But there is like one important difference. And I was even giving a paper, a speech with Jarosław Bełdowski on this at the conference in August in Bucerius School of Law. The difference is such that Weiss judgment was a judgment adopted in good faith, and Polish Constitutional Court judgment was adopted in bad faith. What I mean by this? When Bundesverfassungsgericht delivered a judgment, it was obvious that it is just, you know, sending a ball to the Court of Justice and to the European Commission to start a dialogue and just to, in the tradition of the previous Zolang 1, Zolang 2, Maastricht-Urteil and so weiter, it was obvious that basically as a result of this dialogue, there are certain rules that are established and cleared out. In Poland, the judgment was just in order to block any interference of the Court of Justice into Polish judiciary. So it was just a series of number of pronouncements concerning also the European Convention on Human Rights, just to stop any interference. So just to tell the Europe, please stop dealing with Polish judiciary because allegedly you are acting ultra-virus. So there was no any willingness to go into any dialogue. Okay, it was just pure political instrumentalization of the court. And quite interestingly, you know, I remember that after this judgment, I would say more or less like half a year later, there was a discussion whether Polish government, the previous government, would accept the EU recovery money. And even I remember that Ursula von der Leyen, she came to Warsaw to sign like the initial plan how to distribute this money. It was quite a controversial move by Madam President at that time. And I remember that Polish government started to make some changes in the judiciary in accordance with milestones and in order to get this recovery money. But what is quite interesting that nobody from the government was mentioning the judgment of the Polish Constitutional Court. So allegedly, at this moment, the judgment and this whole argumentation has been totally forgotten, okay? From the point of view of, in order to achieve this political effect, and this political objective was basically to take the money from Brussels and just to most probably use it in order to win another parliamentary elections, in order to create like the further continuation of the illiberal regime in Poland. So if I would like to just sum it up, it's a completely different thing when you are having an independent constitutional court that is entering into good faith dialogue with the European institutions, and a completely different thing when you have a politicized constitutional court that is using its power in a very instrumental political way and is not going to have any discussion, but is just using this power of the constitutional court in order to block any interference and compliance check and supervision from the point of view of the court, from the point of view of the European Union law.
Thank you so much, Minister Bodnar, for taking so much time with us and discuss the... Please, yeah.
Sorry, because
yeah.
I didn't answer your second question. Because your second question was about Court of Justice as such. In my opinion, please note that during this whole process of changes, whatever Commission did and whatever European Court of Justice did, the level of public support for the European integration was always 75%. 72, 75, 77. So Mr. Timmermans could be attacked as hell, but Commission was still regarded as a trusted institution. So Polish society is very pro-European. But I think that the legitimacy of the Court of Justice increased not only because of the intervention in the context of the rule of law, but because there was a series of cases concerning abusive loans, loans denominated in Swiss francs, and basically the court found that they are contrary to the EU directives on consumer protection. And second, because there were some important judgments concerning environmental protection, especially protecting the Białowieża forest, so the forest at the border with Belarus. So in my opinion, this kind of a legitimacy of the court increased because Polish citizens could feel that it is not just about abstract values, but the court delivers important messages and important things for the Polish citizens, and they can later on take advantage of this. So I think it is quite important. So I'm coming back a little bit to one of those lessons that institutions also present how they can deliver something that is beneficial to citizens, and they can properly explain it to citizens. Thank you.
Thank you so much. For EU law teaching, this forest could have had a less complicated name, I would say. At least for us. So before I start with saying thank you to everybody, just you should know that after the event you will have some occasion to have an informal talk outside here. So it would not be advisable just to get, if you want to leave the place, you get down the stairs, but the place for informal discussion is on my right. So I want to say thank you to everybody, to the audience, but of course to Madam President for being with us all the time, to our partners from Stiftung Mercator and also the European Commission. I wish to say thank you to the team of Walter Hallstein Institute and of Humboldt University, because it's a great support you gave us. But of course, I want to say thank you to this evening's speaker, Minister Bodnar. And normally I should have a present near to me, that's it, because you have predecessors that gave speeches before you, and the collection is in here. Thank you so much for being with us. And thank you for... Right inside.